Have you recently been arrested and taken to jail? Did you receive a citation and a notice to appear? Have you received a letter in a mail that tells you that you are now summoned to come to court, and if you fail to appear, a warrant can be issued for your arrest?
Are you feeling nervous or anxious about your upcoming court date and don't know what to expect?
My name is William Pernik. I'm a criminal defense attorney and the founder of the Pernik Law Firm. Here with me is Sarah Schumacher, one of the senior attorneys in our firm. And together, we're going to discuss with you what to expect from your court appearance, how best to prepare before you arrive to court, how to set the right impression in front of the judge and the person who is prosecuting your case, the district attorney or your prosecutor, and how to make sure that you arrive to court and leave the court out of custody. Please watch to the rest of this video, and we will share with you a short list of helpful suggestions that will help you make the most out of your arraignment and stay out of trouble. First of all, we want to talk to you about what your arraignment actually is. An arraignment is a very important procedural step, and one that's going to formally begin a criminal case against you. During the time of your arraignment, the judge will identify your legal representation, will advise you as to what the charges are against you, will address your custody status, meaning whether or not you should continue your case in jail or out of jail, on bail or with terms of release, address any additional terms of your release, such as restraining orders, criminal protective orders, drug and alcohol treatment terms, or perhaps even monitoring through the probation pretrial services department. At the conclusion of your arraignment, you will be expected to enter a plea of either guilty or not guilty. Only a plea of not guilty will continue a criminal case against you and give you an opportunity to defend yourself, to negotiate, potentially for a better resolution or different set of charges. And then finally, the judge will expect to set the case for a particular timeline. It's either going to be on an expedited fashion if you exercise your right to speedy trial or speedy preliminary hearing, or the case can proceed at a much more relaxed pace, which is going to give you and your attorney a lot more time to prepare and to present a defense.
Your arraignment is not the time for a trial. There's a time for that later. No witnesses will be called at your arraignment. It's not the time for you to explain to the judge what happened. In fact, that could actually harm your criminal case because these proceedings are recorded. At arraignment, it's going to be limited in scope, and it's best to let your attorney do the talking for you. If you have a question about what you should say, if the judge is asking you a question directly, you can always look to your attorney for advice on what to say. If you go to court and you have the financial ability to hire your own attorney, you can ask the judge for a continuance to hire an attorney and come to court with an attorney. If you don't have the financial ability to hire an attorney, you can request the court appoint what's called a public defender to represent you. The court's going to ask you about your financial status to see if you qualify to have a public defender appointed.
One important thing to remember is that all of these documents are filled out under penalty of perjury. You do not want to compound your legal situation by lying about your finances under penalty of perjury on the financial declaration form. So make sure you're only requesting a public defender if you truly qualify for one. If you misrepresent your assets or your financial circumstances under penalty of perjury, you can get yourself in a lot more trouble. And oftentimes, that's simply not worth it. Sarah, oftentimes clients call us and they ask us, what should I be prepared to say in court when I show up for my first court appearance?
You don't need to say much at your first court appearance. All that would be addressed is appointment of an attorney or continuance to retain an attorney if you don't already have an attorney, addressing your custody status, entering a plea of guilty or not guilty, and setting your next court date. You do not need to prepare a statement to talk to the judge. That may in fact irritate the judge as they want to move through their arraignment calendar. After you identify who your attorney will be, the next step is entering a plea of guilty or not guilty on the charges.
Please remember, if you are going to court with an attorney, if you are planning to contest what the government has alleged against you, there is only one correct answer to that question, and that is a plea of not guilty. One of the important topics that could come up during your arraignment is the question of your custody status. If you are appearing in court out of custody and there is no issue with the bail that you have initially posted, because the bail has been posted in the correct amount, you will remain out of custody. The judge will simply proceed forward with entry of the plea, discuss the timeline for the case, and set next court dates. If you are appearing in court when you are in custody, you have a number of options. First of all, you can always argue that you should be released from custody for a variety of reasons, including your ties to the community, your lack of prior failures to appear, the fact that you are a person with minimal criminal record, or other aspects of your background or the nature of this case that should make the judge feel comfortable with your release. Our probation departments in multiple jurisdictions will typically have a dedicated pretrial services officer who will prepare a risk assessment, meet with you before your arraignment if you are in jail, and prepare something for the court to consider in order to make a determination whether they should release you outright or do something about your bail or terms of your release. If you are appearing in court and your bail is set really high, if this is the kind of case where there was an escalation of bail request file, you can always ask the judge to lower the amount of bail, and your attorney should be able to make those arguments on your behalf. There are special rules that apply to bail, and these rules state that bail should be set at a reasonable amount that a person can afford to pay. However, in some circumstances, if the crime is really serious or the judge feels that your release will endanger the community, they can make a special finding that you are a risk to public safety and put you in a no bail status at all. In some circumstances, as lawyers, we may need a little bit more time in order to make the most persuasive argument for why your bail is set too high and should be lowered. We have been able to lower bail, sometimes from very high amounts, like $1 million or $2 million, and get it down to the amount our client is able to pay. In those circumstances, an attorney will typically ask the judge to set the matter for a dedicated bail hearing, prepare something in writing, attach additional exhibits, declaration, character letters, and other documents that the attorney feels will reassure the court that the client will appear to court on time and that there will be no further acts that could endanger the alleged victim or victims or witnesses in this case or the community at large.
If the judge releases you from custody, they may impose terms of your release. For example, they may order search terms, meaning that they can search your person, car, or residence for stolen property, for drugs, for alcohol, for weapons. An additional term of your release that may be imposed is what's called a criminal protective order, and this is particularly in domestic violence and child endangerment cases. Those orders will specify that you are to either have peaceful contact with the alleged victims involved, meaning keeping everything calm at home, or in other cases, no contact or stay away orders. Even if those no contact or stay away orders feel unfair, it's important that you abide by those orders until they are modified by the judge if you want to remain out of jail, out of custody.
In fact, if you violate a protective order that was issued at your arraignment, you can be charged with a separate crime and could be facing up to a year in custody. This happens even if the case against you is completely wrong, completely unfair, or completely unfounded. Please do not make the mistake of creating a case the government can actually prove against you when they don't have enough evidence to prosecute you and convict you in the first place. Discuss with your attorney what common steps exist in order to modify the restraining order. Usually, this will happen if you enroll in counseling, address underlying issues that led to the alleged incident, such as overuse or abuse of controlled substances or alcohol, anger management, and couples counseling. Finally, at the conclusion of your arraignment, the judge is going to address the timing of next hearings in your case. There are two options available to the court in how to proceed in both misdemeanor and felony cases. In misdemeanor cases, you can choose to go directly to trial by invoking your right to a speedy trial. That is a right to be brought to trial within 30 days if you are in jail, in custody at the time of your arraignment, or 45 days if you are out of custody at the time of your arraignment. In a felony case, the rules are completely different because you cannot go directly to trial from your arraignment in a felony case without first going through a preliminary hearing. A person always has the right to a speedy preliminary hearing within 10 days if they're in custody or 60 days if they're out of custody. But please be mindful, when you exercise your right to a speedy trial or a speedy preliminary hearing, you're going to significantly expedite the process, which means you and your attorney may have a lot less time to investigate the claims against you, collaborate, and prepare a defense for effective representation in court. As long as you're prepared and you have discussed these issues in advance with your attorney, none of these issues should be a major obstacle for you, and your arraignment should proceed quickly and smoothly. In the beginning of this video, Sarah and I promised we're going to share with you a very short list of tips that you can take, that you can commit to memory, that will help you avoid making a really memorable appearance for your prosecutor and for your judge. Number one, appearances matter. Please make sure that when you appear in court, you act professionally, you dress respectfully, and you address the court in an appropriate and professional manner.
Additionally, this may seem like common sense, but it's not a great idea to come to your very first court date smelling like alcohol or marijuana. Next, be on time.
Be patient when you come to court. There is a certain order in which cases are typically called in court. Normally, people who are in jail go first before people who are out of custody. Even if you are present in court and you showed up first, somebody else's case might be called before yours for reasons that you might not be aware of. Every jurisdiction does it differently, and it's very difficult to predict exactly when your court case is going to be called. If you have an attorney, the best thing is to ask the attorney, do I need to appear? What do I need to bring with me? Sometimes you might want to bring proof that you've attended some counseling, alcohol or drug treatment, or participated in couples counseling with your loved one if this is a domestic violence type of case. After you appear in court, be respectful, be professional, be patient, and your attorney will call the matter shortly. Finally, please remember, don't make speeches when you come to court. This is not an opportunity for you to explain to the judge what happened. It is dangerous for you to be addressing the judge on the record when your statement is being recorded either by audio recording system in court or by a court reporter or stenographer who's typing down everything you're saying. If you're not represented by an attorney, there is a risk that you could say something in court that could incriminate you as you're trying to give an explanation as to what may have happened. As long as you follow these simple suggestions, your first appearance in court should be brief and non-eventful. We really hope you like this video. Please click like, subscribe, let us know if you have any comments, and stay out of trouble. And we'll see you next week.